Oh my god, it's raining Amicus briefs everywhere. What's up, Wolverines? Welcome back to the channel. This is John Crump News, where we discuss 2A every day. I'm your host, John Crump, who talks about 2A every day as an investigative journalist. Before we get into today's topic, which is very, very interesting and involves the Supreme Court, let's go ahead and thank our sponsor. Optics makes some of the best optics at an affordable price. So why spend money on an optic where you can get a cheaper optic that is just as good? Go ahead and check out Gideon Optics, and for a limited time, you can use code CRUMPY and get 10% off and free shipping on all orders. Like, comment, and subscribe. If you're not subscribed, I highly would recommend that you do so. Also, at the end of the video, I'm going to be giving out a keyword, and that keyword will unlock 100 bonus entries in the contest I'm running over on my website. Just Google Crumpy and you'll be able to find my website and enter to win a incredible stire. Okay, guys, we're going to be talking about the Rahimi case. If you don't know about the Rahimi case, look around there. This should be a card and you can find out more information about Rahimi. But if you don't want to do that, I'm going to give you a incredibly quick breakdown. There's a lot more to this case, but you can watch the video if you so choose. Rahimi was a guy out of Texas that was a domestic abuser and an all-around dirtbag. I mean, he shot at people and stuff like that, so there's that. But he was charged with having a firearm and being a domestic abuser, which you're not allowed to do. So he appealed and won at the circuit level, stating that it is unconstitutional to block domestic abusers from having firearms. It was appealed to the Supreme Court, and that's where it sits now. Now, Rahimi is a terrible representative of the Second Amendment community, but this case is much more than just him. This case involves a lot of different Second Amendment arguments, and we are going to go over the ones that the anti-gunners have submitted through Amicus briefs, or Amicus briefs, however you want to say them. Today, they submitted 37 of them. 37. There's a lot of common themes through the whole entire process, and we will work through those right now. Now, what an amicus brief is, or amicus brief, is a briefing that is filed as a friend of the court, meaning that the parties are not directly related to what is being argued, but they have some type of expertise or insight into the case. We see this in a lot of cases. Both sides submit amicus briefs, the pro-gun side and the anti-gun side. In almost every Supreme Court case, there's amicus briefs from everywhere. And now let's go over what the 37 that were submitted today actually said. They all come from anti-gun groups, of course, and they all back the government's prohibition of domestic abusers with firearms. I'm going to go over a few of their arguments. I made a lot of notes. I read through a lot of them. I have not read through all of them, but I'm going to tell you what I found in them, and you can go ahead and read them yourself. They are on the Supreme Court website. Okay, first, none of them say that there's any analogs to the law that bans domestic abusers from having firearms. Remember, in Bruin, the Supreme Court said that a law has to be consistent with the text, tradition, and history of the Second Amendment, meaning that once it is clear that the text is what it is, it shifts the burden into the government to prove that their law is consistent with the history and tradition of the Second Amendment. None of the amicus briefs point out laws from 1791 when the Declaration of Independence was ratified. Remember how I said a long time ago that they're going to start using the 14th Amendment, and they already did in the 11th Circuit, for example, where they used the 14th Amendment ratification date instead of the Second Amendment ratification date. This is exactly what these anti-gunners did. And they did this because there's no analogs that they can point to in 1791, so they're going to use 1868. Now let's think about that time period around 1868. The Civil War had just ended, and blacks were freed across the South. And white landowners in the South were afraid that the blacks were going to get guns and exact revenge. So they started the Jim Crow era, where they passed a bunch of racist gun laws to prevent black people from getting firearms. So when people say all gun laws are racist, they are, and all gun groups are racist, and this just proves it because they are citing anti-black racist gun laws in their amicus briefs. One good thing that can come out of this case is this can be settled once and for all. The Supreme Court can say that we were talking about the ratification date of the Second Amendment and not the 14th Amendment. The 14th Amendment basically took all the Bill of Rights and applied it to the states. Before that, there was some type of argument that the Bill of Rights only applied to the federal governments and not the states, but the 14th Amendment changed that. So that's why they keep on trying to use the 14th Amendment. All right, now check this out. They're trying to substitute military for militia. That was settled in Heller, yet they are trying to rewrite that and say that the militia is the military, and you and I do not have an individual right to own a firearm, which was settled in the Heller decision back in 2008. The militia is the people. What they do is they point to historical examples of where militia was used to refer to a military and said, see, look, they're talking about the military, which is a bunch of BS. And I think the Supreme Court is going to reject that. The anti-gunners are trying to bring back interest balancing, where the rights of the people are weighed against the will of the state. Basically, they are trying to go back to intermediate scrutiny, which was knocked down during Bruin. They use an emotional plea for this. They list a bunch of statistics and situations about people using firearms in not so healthy ways. They highlight criminals using firearms and deaths and everything else. They are trying to pull on those heartstrings to bring back intermediate scrutiny. I think this will fail because Judge Thomas was very, very clear in the Bruin decision that intermediate scrutiny cannot be applied to the Second Amendment. It is only original text, history, and tradition of the Second Amendment. Talking about original text, another thing that they are trying to do, and this is kind of comical, is pointing to other proposals during the whole entire debate about the Bill of Rights, saying, look, this was proposed and this was proposed. But the thing is, none of that was passed. That is equivalent of some crazy person in Congress putting in a bill that does something insane and saying, well, someone proposed it, so therefore you have to consider that when you're weighing this court case, which is ridiculous. If that was the case, I would ask Thomas Massie, or one of those guys, to propose a bill that every American gets a machine gun, and then I will sue not because the bill passed into a law, but because it was just proposed. So that does not have the weight of law behind it. A proposal does not have the weight of law. And yet, this is what this anti-gun coalition is trying to do. What they are trying to do is confuse the judges and also pull on the judges' heartstrings to get them to roll for the government side, which would forbid Rahimi from having a firearm because he is a domestic abuser. And I think it will fail. This is the case that the anti-gun side wanted to go up to the Supreme Court because Rahimi is not a good guy, and we can't run for that. But as a gun rights community, we have to be willing to state that this case is bigger than Rahimi. Rahimi might not be a good guy, but this case is about thousands of other people that get caught up in the trap where they get their firearms stripped away with little to no due process. Just because someone is accused of something does not make them guilty of that. Think about this. Let's say that you are one of the thousands of people that have a domestic restraining order against you, and you actually did nothing wrong, but the person that has the domestic restraining order against you have an evil plot, and they want to disarm you to make you vulnerable to whatever evil plan that they have. That might seem far-fetched, but it does happen. So we will see what the anti-gun side does next, if there's any more coming in, which there probably is, or what the pro-gun side does to respond to these amicus briefs. We should have those in about a month or less, so we'll see what happens at that point. I know there's a bunch that will be filed, and hopefully they make strong arguments, because the anti-gun side is going to rely on emotion to try to get their way in this case. I just really hope that it does not work. All right, guys, remember the secret word of the day is T-Bird. T-Bird is the secret word of the day. I'm not really sure what that has to do with anything. I just made it up on the fly. But enter T-Bird over at my website and enter in to win a Steyr pistol. Also, guys, remember there's lots of ways to support independent journalists like me, and they are listed below. All right, guys, stay ever vigilant, stay ever free, keep in the fight. I am out of here. Wolverine's mother...